Hi again, welcome back. My name's Sarah Leggett. I'm from the Sartwell Nation on my mom's side. I'm Simshian from Loch Wallams on my dad's side, with Scottish and Norwegian ancestry. I am the lead policy analyst here at SIA. I formerly was a social worker and worked with local agencies.
Hello, it's Rachel. Welcome to our third video in our series where we go over our draft law. My name's Erica. I'm of settler ancestry, primarily from Slovenia, Ireland, and Norway. I'm the quality assurance lead here at SIA, and we're looking forward to going over minimum standards with you all today through this short video.
Hi everyone. Okay, so today I will be talking a little bit about the minimum standards or national standards outlined in Bill C-92, also known as an act respecting First Nations, Inuit, and Métis children, youth, and families. So one of the most important things about Bill C-92 is that it recognizes and upholds Indigenous peoples' inherent jurisdiction over child and family services, which grants IGBs or Indigenous governing bodies the right to pass their own child and family service laws, such as SIA is doing right now. But as with many rights that are granted via legislation, this inherent jurisdiction is subject to certain restrictions, such as the fact that laws that are passed by IGBs must not conflict with the Canadian Human Rights Charter of Human Rights and Freedoms or the Canadian Human Rights Act, and these laws cannot be contrary to the best interests of the Indigenous child. So the best interest of the Indigenous child is sort of a guiding framework for some of the other principles and minimum standards that must be adhered to by both federal and provincial governments as well as Indigenous governing bodies. And these standards were developed kind of with the help of Indigenous advocates and scholars who were advocating for standards that would hold provincial and federal governments accountable and ensure that Indigenous children and families were not subject to so much child removal via the child welfare system. And so in the old legal test, which was just called the best interest of the child test, service providers would kind of apprehend Indigenous children, and then courts would rule that it's in the best interest of the child to be removed from their family. But this new test acknowledges that there are unique factors that sort of must be given more weight in the context of Indigenous children and families, such as the importance of having an ongoing relationship with their family and their Indigenous community, and preserving the child's connection to their culture. So there are several sort of related elements to the best interests of the Indigenous child standard, one of them being cultural continuity, which means that no action that is taken by a child and family service provider should contribute to the assimilation of the Indigenous child, and an acknowledgement that a child's best interests are promoted when they're sort of immersed in the culture of their family and community. Another minimum standard is substantive equality. So this means that there should be equal outcomes for Indigenous children and families despite any differences based on factors such as disability, sex or gender identity, or on or off reserve residency, as well as other factors. And so in SIA's draft law, we've specified in relation to substantive equality under section 3.4 that Indigenous guests will be treated equally to children or families from the member nations. And one way to kind of ensure this is to enshrine Jordan's principle in our law, which guarantees that any jurisdictional disputes between IGBs will not result in a gap, denial, or delay of services to a family just because they are an Indigenous guest that are not living within the territory of their own IGB. Another important aspect of the Federal Act is the requirement to prioritize preventative care. So this means, for example, helping a family with in-home support if they're struggling, rather than prioritizing other actions such as apprehension of the child. Along with this comes the prioritization of prenatal care. So if there's an expectant parent who is maybe unsure of whether they're able to raise a child, putting those supports in place or a plan in place before the child is born should be prioritized. The Act sets out also a priority placement list, which service providers must adhere to. So the Act essentially says that a child must first priority be placed with their parent or one of their parents, then with an adult member of their family, then with an adult that belongs to their community, then with an Indigenous adult who may belong to a different community, and then lastly with any other adult. So this is a minimum standard, so new laws must adhere to it, but IGBs could also restructure these standards or add to them in order to make it reflect their own cultural processes or legal principles related to things like customary adoption, for example. Or, for example, they could put in a priority that a child be placed with a member of their own clan within the nation, or some other way of organizing that reflects the laws of that particular nation. The Federal Act also requires that service providers, such as social workers, make reasonable efforts to have a child continue to reside with their family before apprehending them. So this means that those service providers may need to demonstrate to a court that they've sort of exhausted all other options and apprehension was a last resort before they are able to go through with an apprehension. But some scholars have kind of critiqued the reasonable efforts standard and advocated for a more onerous active efforts test, which would require service providers to take affirmative action to maintain or reunite Indigenous children with their families. So an IGB could potentially adopt a test or a more onerous standard like active efforts, but the minimum standard that is required is the reasonable efforts test. The Act also stipulates that service providers cannot remove a child based solely on socioeconomic conditions. So this means if a family is experiencing poverty or housing insecurity or health problems, then the service provider should help the family to overcome those challenges rather than removing a child based on those challenges. And so an IGB like SIA can kind of adapt these national or minimum standards in ways that aligns more closely with the culture or laws of the nation that is passing them. So, for example, you could define, instead of the best interests of the Indigenous child, you could say the best interests of the Anishinaabe child or the best interests of the Coast Salish child. And SIA's kind of done that throughout the draft law that we've created. The core section that does deal with minimum standards is Section 3. But there are other sections throughout the law, such as, we have a whole section on priority placement, and even some of our guiding principles incorporate some of these standards in a way that is unique to the South Island nation. And instead of just word for word incorporating what the Federal Act says, SIA has listened to community feedback and found ways to incorporate these minimum standards and articulate them in a way that meets the requirements of the National Act, but also reflects the unique priorities and values of the South Island nations.
So, Section 3.2, Best Interests of the Child. And this is where we have a list that outlines what are the best interests of a child and how does that come out of community and how have we, what does that look like within our law and what are the best interests for Indigenous children living here on the South Island, both from our member nations as well as our Indigenous guest community. And this section is so important because the best interests of the child need to be taken as a primary consideration in decisions or actions that are taken under this law, and the paramount consideration when support measures include separating a child from their parent. And so really this is guiding those decisions. It's to be able to look through, and it's all coming from those voices in community saying, this is what we want for our children. This is what's important for our children.
Right, so 3.2.2, within our law, we define that the most effective means of ensuring a child's best interests are when they remain connected to family, to culture, to community, their identity, and that is also in with collaboration and consideration of the family. We feel that is really important. And then 3.2.3, again, to ensure that we prioritize the best interests of a child. We recognize within the law that reasonable efforts must be made to include the child or the youth, their views, their preferences, their feelings within all decisions made regarding them.
So as we were deciding how to do this little video, we thought it was really important actually to go through our list of what is in the best interest of an Indigenous child who is served and cared for under this law. And so Sarah's going to read those out. They're really powerful statements. And again, these are statements that have really come from community to be put into the law in this way, of the things that community and elders have said this is what matters, and we know how to define the best interest for our own kids. So take it away.
Okay, so our list, as you can see, it goes from A to M. So A, we believe the best interest of a child includes the right of children to know their identity, their ancestral rights, their family histories, family beliefs and teachings. The next one, B, the right of the child to have a sense of belonging, to know who they are and where they come from. C, the right of a child to have access to an opportunity to learn their language. D, the right of a child to be connected to their community, and specifically have access to elders, knowledge keepers, those that can help guide them throughout their lives. E is the right of a child to have access under the direction of their family to ceremonies, to protocols, opportunities that enable them to exercise their sacred ancestral rights, and to remain connected to their culture and participate in ceremony. F, the right of the child is to consistently feel safe, loved, and secured. And then we're on to G, the needs of the child given the age and stage of their development is also in consideration. So, children can have a voice, or we're ensuring that a child has a voice in decisions that are directly impacting them. H, the importance of a child maintaining strong and positive relations with their family and being cared for by their family. So, given whatever circumstance, they still remain connected to their family, and that opportunities are provided to keep that connection strong. I, the importance of the child in preserving connections to the territory of their nation and access to traditional foods. So, wherever a child lives, ensuring that they have access and they have the right to be on their territory, to set foot on their territory, to know their territory is really important. J, the views and preferences of the child, given their age and maturity, are also included in every decision made regarding them. K, that family violence and its impact on the child, including whether a child is directly or indirectly exposed to the family violence, as well as the physical, emotional, and psychological harm or risk of harm to the child. L is the right of the child to feel safe from abuse and neglect. So recognizing, children have the right to feel safe. And then M, that any civil or criminal proceeding, order, condition, or measure that is relevant to the current safety and well-being of the child, including for orders such as orders, conditions, and measures pursuant to the authority of the member nations.
So in our law, we have to explain and elaborate on how we are going to support the cultural continuity for those under our law, and to not contribute to any more ongoing assimilation of Indigenous peoples within our world and in our service delivery system. And really, we've just acknowledged, even in this first statement, that cultural continuity is essential to the well-being of children, youth, young adults, families, and communities. Children are that next generation. They're the ones who are going to carry culture forward, and recognizing that of utmost importance in every action that we do under our law.
So 3.3.2, so we established that we need to promote cultural continuity services provided under this law, and that we need to preserve or foster connection to culture, to family, to community, to the land, to teachings, to languages, that everyone under this law has the right to that. 3.3.3, within the law, the member nations respect each other's distinct cultures, and that the distinct cultures of the indigenous guests on these territories. We also recognize that we will not contribute to the assimilation and destruction of these distinct cultures. And then 3.3.4, and that we know outlined within the law that individuals should respect the distinct culture of the nations on whose territories we're on, under the law as well. So
substantive equality. That is that understanding that we all come into life and into receiving services with different needs and abilities and experiences. And I'm going to put a little image of this within this slide. But that understanding, like if you give everyone the same size ladder to peer over a fence or something, those who are taller, that's going to benefit them and they can look over. But those who might be shorter in stature, that's not going to help. They actually need a taller ladder. And so it's really acknowledging the distinct needs and rights of children under this law, and to promote substantive equality between a child serviced under our law and other children. And so this substantive equality needs to be considered in order to promote a child's participation to the same extent of other children in the activity of a child's family, community, member nation, or the communities that they belong to. And that a child and members of their family should be able to exercise their rights under this law without discrimination. And really, this is also where Jordan's principle comes in, which within this section talks about to promote substantive equality between all children, we must ensure that jurisdictional disputes must not result in gap, denial, delay, or disruption in child and family services that are provided in relation to a child. And so this is really us getting in front of this and saying, if a child, maybe they belong to multiple nations, maybe there's the question of whether they're going to be served by the province or what have you. In a certain way, it's saying, you serve the child first, you serve the family first, and then you figure out funding later, as a way of promoting that substantive equality.
okay, so that is the end of us going over the minimum standards. Please check out our website. We have, social media. We have TikTok. We have Facebook. Please check those out. And of course, if you have any questions, please reach out to us through the website.
And we're also I'll put them in the link to this video, some other helpful resources about how minimum standards are understood under the Act, the Federal Act, for further exploration for those who are curious. So see you in our next video.